Sir, I hope I'm audible now.
Yes, you are properly audible now.
Okay. Good morning again to all the respected panel members. With your permission, I would like to start the session.
Yes, yes,
Thank
yes.
you. Hello and good morning, everyone. I'm Akshar Aditya, Senior Content Editor at Jus Corpus. It is my great pleasure to welcome you all to the fourth virtual conference towards gender justice, reassessing laws, societal barriers, and the path forward. Jus Corpus is proud to present this fourth virtual conference, continuing the legacy of fostering meaningful dialogue and collaboration that our previous three editions have built. Since its inception, our conference has carved a distinct and respected niche in the global discourse of women's rights and gender justice, evolving into a premier platform for legal professionals, scholars, policymakers, and activists. This edition in particular emphasizes actionable strategies for promoting gender equality. Our objectives are to conduct a comprehensive analysis of existing legal frameworks and identify areas where reforms are necessary, thoroughly analyze the societal, cultural, and economic barriers that impede the progress of gender justice, foster a deeper understanding of intersectionality and its impact on gender justice, advocate for and promote inclusive participatory approaches to legal and social transformation, centered on the voices and experiences of women and marginalized communities. We are confident that by drawing on the lessons from our past conferences and the collective experiences of today's participants, this event will catalyze tangible change. I would like to extend our gratitude to the organizations that have made this event possible. This conference is presented by Jus Corpus in collaboration with several esteemed institutions. The School of Social Sciences and Interdisciplinary Studies at Rajiv Gandhi National University of Law, Punjab, the Institute of Legal Studies at Sri Ram Swaroop Memorial University, Lucknow, and the School of Law at Sharda University, Greater Noida. We are proud to be associated with and sponsored by Lectio Law Offices and Chambers of Abhinav Mishra, advocates and solicitors. Jus Corpus is an edtech platform founded in 2020 by a group of legal professionals who wanted to bring various aspects of law under one umbrella. We also run the Jus Corpus Law Journal and the International Journal of Law Research Education. Lectio Law Offices is a leading law firm in India, known for its client-focused and strategic approach, providing tailored solutions across various practice areas, including dispute resolution, white-collar crimes, and family disputes. Chambers of Abhinav Mishra Advocates and Solicitors, established in 2018, is known for its diverse capabilities and for providing strategic and innovative legal solutions across. The School of Social Sciences and Interdisciplinary Studies at RGNUL is a dedicated center that promotes interdisciplinary academic engagement by integrating fields like political science, sociology, economics, and law to address contemporary challenges. The Institute of Legal Studies at Sri Ram Swaroop Memorial University is a premier institution with a focus on producing legal experts in various fields, including litigation, corporate law, and mediation. The School of Law at Sharda University is committed to academic excellence and preparing future legal professionals through programs that emphasize experiential learning, research, and social justice. Now, without further ado, let's welcome our distinguished speakers. Firstly, I would like to invite Ms. Shakshi Batham ma'am for the welcome address. She is a purpose-driven professional working at the intersection of law and media and management. She currently serves as the co-founder and chief operating officer at Jus Corpus, where she leads strategic initiatives, operations, and partnership to advance legal research and innovation. She is also the co-founder and publisher of the International Journal of Law, Research, Education, and Social Sciences, a multidisciplinary platform amplifying academic voices across law, management, humanities, education, and social science. pursuing her PGDM at IILM. She is strengthening her expertise in business strategy, operational leadership, and communication. Passionate about bridging law, business, and academia, she actively contributes to shaping the evolving legal tech and research ecosystem. This.
Good morning, everyone. On behalf of Jus Corpus, I'm truly delighted to welcome you all to the fourth virtual conference. It is both an honor and a privilege to address such a distinguished gathering of academicians, legal professionals, researchers, and students who have joined us today from across different institutions and jurisdictions. At Jus Corpus, our mission has always been to create a platform that bridges the gap between legal research and practice, encouraging meaningful dialogues, critical thinking, and innovation in the field of law. Over the years, we have strived to provide opportunities for young scholars to showcase their work, and I am proud to say that this conference reflects the same. This year's conference brings together some truly thought-provoking papers and discussions on pressing legal and social issues, and I'm confident that the insights shared today will not only enrich our understandings but also inspire new perspective and collaborations. I take this moment to extend my heartfelt gratitude to our keynote speakers, esteemed judges, and our partner institutions who conference to make this possible. Special thanks to also goes to our dedicated at Just Corpus who have worked tirelessly behind the scenes. With that, let us begin this journey, our exchange, learning, and inspiration. I wish all the participants the very best for their presentation and looking forward to the engaging discussion ahead. Thank you.
Thank you so much, ma'am. Next, with utmost regard and gratitude, I would like to invite our guest of honor for today's event, Honorable Mr. Justice Subodh Shah, for his address. He is a distinguished former judge of the Gujarat High Court, where he served with distinction for 22 years and decided nearly 17,000 cases across constitutional, civil, criminal, and commercial law. Known for his judicial acumen and integrity, his judgments have had a lasting impact on legal practice and policy. Following his retirement in 2019, Justice Shah has been actively engaged in arbitration, presiding over a range of complex disputes. He also served as a member of the Supreme Court Standing Committee monitoring the e-committee, playing a pivotal role in advancing the computerization of courts across India. A sought-after speaker, he has delivered lectures to judges, judicial officers, professionals, and students across the country and addressed national conferences on forensic science. Even today, Justice Shah continues to contribute to the legal fraternity through mentorship, scholarship, and his unwavering commitment to the rule of law. Sir, the stage is yours.
If you want something to be said, ask a man. But if you want something to be done, ask a woman. Respected organizers, esteemed academicians. Am I audible?
Yes, Lordship, properly.
Okay. Respected organizers, esteemed academicians, legal professionals, students, and participants, as well as all who are present here today. Good morning. It is a great honor to join you today for the opening of this international virtual conference on women's rights, hosted by Jus Corpus. I thank the organizers for inviting me to speak on a topic of lasting importance. Margaret Thatcher's famous saying, as I started with it, that if you want something said, ask a man, but if you want something to done, ask a woman, is more than just a clever remark. It highlights a truth. Words may inspire, but action transforms. Throughout history, women have been seen those agents of agencies and agents of change. In law and constitution, this holds special meaning. Women's rights were often acknowledged in principle but not always enforced. Declarations of equality, charters, and conventions remained hopeful words unless women pushed for real action. It was their persistence as petitioners and leaders that turn promises into rights. Looking at legal progress, major advances in gender justice, whether in property rights, protection from violence, workplace equality, or personal freedom, it came because women demanded enforcement, not just recognition. Courts have gradually shifted from words to real remedies. The quote I have started with reminds all institutions, including courts, that justice isn't about equivalent words in judgments or laws. It is about what is actually done to ensure dignity, equality, and opportunity for every woman. Turning that promise of equality into reality is both a constitutional duty and a moral obligation of all of us. Our culture in Gujarat specifically has a saying, if water is there in well, it will come up in the bucket. This teaches us that results reflect what's inside us. Institutions can only deliver justice if they truly hold fairness, equality, and empathy. Rights on paper mean little without genuine commitment behind them. This is especially true for women's rights. For centuries, dignity was spoken of but not always respected. Only when society truly values justice, it can meaningful change emerge from laws and governance. Women's rights are central to our constitutional democracy. Our constitutional framers knew the historical disadvantages women faced and guaranteed equality, dignity, and non-discrimination. Articles 14, 15, and 21 assure women equal standing in all parts of life. These ideals come alive in judgments like Saira Bano versus Union of India, which struck down instant triple talaq and affirmed women's autonomy in marriage. We meet today to renew our commitment to fairness and justice. These ideals aren't abstract, they affect real lives. For example, in Muhammad Ahmad, a minor versus Union of India, the Delhi High Court ordered free enzyme therapy for a child with a rare disease, showing that dignity and access are rights, not privileges. Still, the gap between constitutional promises and social realities remains wide. Despite laws and court rulings advancing gender justice, women in many parts of India and beyond face systematic barriers, stereotypes, and violence that threaten their dignity. The law cannot stay fixed. It is not static. It must adapt to society's changing needs. Courts have interpreted laws with sensitivity to women's rights, expanding liberty and equality. But true change requires a cultural shift, starting at home, schools, workplace, and public conversations. We must confront everyday bias and microaggressions. Legal reforms must go hand in hand with social reforms, grounded in empathy, education, and accountability. Our constitutional promises result from a long struggle. We stand on the shoulder of giants like Raja Ram Mohan Rai and Chandra Vidyasagar, who fought oppressive practices, and the women freedom fighters who insisted gender equality to be part of our constitution. The fight crosses the border. International agreements like CEDAW, that is Convention on the Elimination of All Forms of Discrimination Against Women, provide a global blueprint for gender justice. A setback for women's rights anywhere is a setback for humanity everywhere. For instance, Argentina's 2020 abortion legislation showed the power of persistent civil action. In recent decades, women's rights have advanced through key laws and movements. India's Hindu Succession Amendment Act 2005 gave daughters equal property rights. The Criminal Law Amendment Act 2013, passed after the Nirbhaya case, bordered definitions of sexual violence and toughened penalties. Globally, CEDAW's ratification by over 180 countries and the Me Too movement have spurred reforms. Countries like Rwanda have shown political will, which it can lead to women holding over 60% of parliamentary seats. These examples proves that when legal reform meets civic courage and institutional support, progress will happen. Yet, in recent years, we have also seen setbacks from brave protest in Iran for bodily autonomy to challenges to reproductive rights elsewhere. The global situation remains unstable. We must stay alert, vocal, and united for justice. Recent developments highlight the judiciary's growing role in affirming women's rights as foundational to constitutional governance. In India, courts have broadened Article 21 to include reproductive autonomy, workplace dignity, and freedom from gender discrimination, making a justice a lived reality. Internationally, agencies like NSF, National Sanitization Foundation, and Environmental Protection Agency, EPA, prioritize women's health research. Philanthropy like Melinda's French Gates 1 billion pledge for gender equity shows how much work yet to be done remains. The United Nations Fund for Population Activities and its 30th anniversary of the International Conference on Population and Development dialogues to grassroots movements in Latin America and West Asia. The global picture confirms that gender justice is not just a social goal, but a legal must. One, needing courage, sensitivity, and ongoing self-examination by institutions. Our legal system's strength lies not just in laws and ruling, but reflecting the realities of those it serves. Today's discussion is more than theory. It reaffirms our constitutional promise to uphold dignity, equality, and justice for every woman. I applaud Jus Corpus for creating this space where law and conscience meet and dialogue can speak change. As you explore these themes, remember the hard-won legal victories, landmark decisions from Visakha lines on workplace harassment to abolishing instant triple talaq in Sairo Banu case, which show law's power as a tool for liberation. But journey is far from done. We must think beyond gender to the full complexity of identity. Women from tribal communities with disabilities or from poor background face unique, layered struggles. An intersectional approach is essential. It's not just theory, but a moral duty. Policies and laws must account for these compounded vulnerabilities. One size fits all solution leave out those who need help most. Look at SEVA, Self-Employed Women's Association, which empowers marginalized women economically, socially, and politically. Empowerment through education, economic independence, and leadership is crucial. Education is more than personal growth. It is the key to autonomy and civic engagement. Rising female literacy and higher education enrollment in India are already changing norms. Economic empowerment through credit, entrepreneurship, and workplace inclusion helps women break dependency cycles. Programs like SEVA and Stand Up India by government show how targeted support transforms lives. Still, women's leadership representation remains uneven. Whether in boardrooms, legislature, or courts, women's presence matters not just for fairness, but to bring diverse views to decisions. Real progress means creating environments where women don't just benefit from reforms, but lead them. To make this goal lasting, institutions and policymakers must act on multiple fronts. Laws should be regularly reviewed to remove gender bias and match social realities. Investments in women's education, especially in STEAM, that is science, technology, engineering, and mathematics, so also in law and public policy, can build future leaders. Economic progress should go beyond credit access to include skill training, market links, and digital literacy. Institutional tools like gender audit cells, complaint committees, and leadership quotas must be strengthened. And data should be broken down by gender, caste, disability, and region for smart policymaking. Together, these steps can build governance that truly transforms. This conference brings together diverse views to tackle these challenges and find inclusive solutions. Academic and research institutions play a vital role as space for reasoned dialogue, global perspective, and innovation. The international scope of this conference shows women's rights cross borders and are key to humanity's progress. These institutions should also nurture leadership. We must mentor women scholars, jurists, and activists to carry justice forward. Representation matters, not just in numbers, but in influence and voice. To the young people here, the future belongs to you. Whether the lawyers, judges, policymakers, or academics, you must make equality and dignity real in daily life. The Viswa guidelines, born from tragedy, change the workplace norms. Let this remind you that adversity can speak reform when met with courage and clarity. Your role is essential. You are not just inheritors of constitutional values. You are their protectors and future reformers. Justice doesn't bend on its own. It bends because people like you challenge injustice and imagine new possibilities. I will recall one of my case where even before the amendment for Indian Succession Act, I have filed a suit by a lady, a deserted wife, who succeeded 3 divorce petitions filed by her husband, and because his husband doesn't want to keep her, she has to live separate, and therefore we file a suit for maintenance, tridhan, and partition in the properties of a husband. The civil court was angry. The High Court was surprised. The division bench of the High Court has asked me a question that, Mr. Shah, what is your appeal for? Are you filing a partition suit for a wife, a lady? And ultimately, after 2005, it is a reality. So we have to start from somewhere. Justice must connect with culture and emotional realities of those it serves. So take the example of Nari Adalat in Gujarat, women-led community courts that resolve disputes through dialogue and empathy. Fairness thrives where trust is built, not just in formal courtrooms. Let this conference be more than reflection. Let it spark action. Whether you make policy, argue cases, teach students, or lead movements, do so with conviction and compassion. The fight for women's rights is not history, it is a living story, and you are its next authors. Remember, the constitutional vision that guides us. India's constitution, adopted in 1950, was revolutionary. It reimagined society, guaranteeing equality before law, prohibiting sex discrimination, and protecting life and liberty. These were not symbols, but commitments to end centuries of and build a society where women live free and with dignity. A society's worth is measured by how it treats its women, and not its GDP or military strength or technology, but dignity, equality, and justice for every woman, regardless of caste, class, creed, or circumstances. Let that truth sink in. The answer is not only in laws, but in lived experiences. And those experiences show we still have a long way to go. The law simply reflects who we are and guides who we want to be. The judiciary has been a force for a change. And in Visakha's case, the Supreme Court gave guidelines against workplace sexual harassment using international law and constitutional principles. A workplace that tolerates harassment is not just unsafe, it is unconstitutional. Empowerment requires accountability and not tolerance. Whereas in Saira Bano, the court struck down instant triple talaq, affirming personal laws must align with constitutional values. Whereas in Joseph's time, adultery laws were struck down, recognizing women are not their husband's property. These rulings are moral declarations, not just legal milestone. But progress is not done. Outside courts, the reality is harsh. A woman is assaulted every few minutes. Girls are denied education. Widows are ostraced. Working women face pay gaps and are often ignored or disrespected. Economic inequality blocks women's workforce participation. Political representation is low. Intersectional discrimination hits Dalit, tribal, trans, and disabled women everywhere. True inclusion means not just access but agency. Women with disabilities must be leaders, not exceptions. Law is not a shield to admire, it's a sword to wield by judges, lawyers, and every citizen who values justice. As a judge, I have seen women reclaim their children, homes, and voice. I have seen their strength and their resistance they face. Women fight for custody, inheritance, protection, and dignity, but delays, procedural hurdles, and empathy erode their faith. Courts must be more accessible, procedures more sensitive, and judgments more transformative in support of women's power. But I have also seen limits, delays, breaking spirits, intimidating procedures, institutions failing to listen. We must do better. The legal profession must reflect women remain underrepresented in courts, bar association, and legal academia. Only a few women have served as a Supreme Court judges. Gender bias, lack of mentorship, and structural barriers block progresses. Breaking gender bias uplifts not just women, but justice itself. Gender diversity improves justice by adding empathy, perspective, and balance. Are our legal chambers inclusive? Are bar associations representatives? Do law schools teach gender justice as a core lens, not just a chapter? We must ask and answer honestly. Without women in lawmaking, interpreting, and teaching, the law is incomplete. Representation is structural, not symbolic. Women must be decision makers, not just litigants. This requires policy change and cultural shifts. In today's digital age, new threats emerging, cyber stalking, online abuse, deep faking, curse. These are not future risks, but present realities. Laws must protect women online also. At the same time, technology like blockchain and AI should empower, not exclude women, but to include them, to protect them. Every technical advancement must also advance equality amongst all. Legal literacy is also essential. Every woman must know her rights. Every girl must learn her voice matters. Every community must be ready to fight injustice. Economic empowerment is key too. Equal pay, maternity benefits, workplace safety, and property laws must be enforced. Women entrepreneurs, especially in rural areas, need legal and financial education. MSMEs, digital platforms, and cooperatives offers new changes, but laws must support their needs. Let's bring the law out of textbook and into everyday life. Make it language every woman can understand and use. India's journey is linked to global commitments. As a CEDAW signatory, India must eliminate all gender discrimination. The Beijing Platform for Action sets goals in education, health, and policies. Global success like Rwanda's gender quotas and Sweden's parental leave offer lessons, but solutions must fit our culture and realities. As you know, some act may be proper in foreign or so-called developed country, but our culture doesn't allow it. Showing nudity or showing personal feelings in open places. When women lead globally, peace lasts longer. policies are kinder, and progress is fairer. Here are some practical steps. Expand fast-track courts for gender violence. Boost legal aid for women in rural and marginalized areas. Enforce workplace anti-harassment laws and flexible work policies. Improve gender disaggregated data collection and require gender sensitivity training for judges, lawyers, and police. To every woman here, you are not asking for favors. You are demanding equality. You are the future of law. Make it kinder, braver. I recall a case of a woman fighting for her child's custody against great odds. Her courage and determination showed me justice is more than legal outcomes. It is a human hope. Judges must listen not only to words but also to silences. We must interpret law with logic and compassion. So get rise, not just in ambition, but in purpose. Carry forward a society where dignity is unconstitutional and equality is real. The Constitution gives you tools, now raise your voice. I congratulate the organizer for this important initiative and for gathering such distinguished group. I am confident this conference will enrich the discussion on women's rights and help build a fairer society. Let this be more than a ceremony. Let it speak action. Commit to measurable results. Measurable results, policy, research, or grassroots work. The time for empty gestures is over. Now we need steady strategic effort. Let this conference renew commitment. Women's rights aren't solo fight. They are shared duty, a constitutional promise, and a moral call. As we live today, remember, justice delayed is dignity denied. And every voice for equality echoes through history. Don't just watch change happen, help build it. We must mentor young professionals to act with integrity and clarity. When junior ICAI disciplinary committee members used clear templates and precedents, their orders showed conviction, not just compliance. That's how culture changes. From courts to classroom, from policy to protest, the story of women's rights is written by those who dared to break silence. Every reform, ruling, and raise voice takes us closer to justice. Let's commit to justice in practice, not just words. From Visakha to Joseph, from bylaws to arbitration, each reform proves silence can be broken, systems rebuilt, and dignity made law. As I close, let's carry not just today's words, but the responsibility they call for. Women's rights are true measure of our democracy. I urge everyone here to engage not just as a scholar or lawyers, but as guardians of justice. May your conversations be bold, inclusive, and empathic. Thank you again to Jus Corpus for this opportunity. I officially open the International Virtual Conference on Women's Rights with hope, conviction, shared commitment. Remember, law is not a monument, it's a movement. As Justice Ruth Bader Ginsburg said, women belong in all places where decisions are being made. Have a great day to all joining virtually. With what I am honored to inaugurate this conference and wish it every success. Thank you. Jai Hind. At the same time, I'm really sorry to say, pardon me to leave. I would not be in a position to listen other dignitaries because I have to honor the ladies of my family, females of my family and relatives who has performed 8 to 30 fast during last months of Jain Paryushan. So I have to attend those functions. Thank you all of you. Jai Hind and pardon me. Thank you.
Thank you so much, sir, for your kind insight and opening the stage for the discussion. Starting with our keynote address, I would like to invite Professor Dr. Vageshwari Deswal, a distinguished law professor at the University of Delhi, specializing in criminal law and gender justice. She is an academician, author, feminist, columnist, and activist, with 8 published books and numerous research articles in leading journals. She has undertaken research projects for NCW, NHRC, and ICSSR, and her blog, Legally Speaking, is published by the Times of India. A regular resource person at judicial academies and training institutes, she frequently appears on Doordarshan and Sansad TV for legal discussions. She has been actively associated with the Department of Legal Affairs, Ministry of Law and Justice, in spreading awareness on India's new criminal laws. Notably, she authored the first three textbooks on these new laws. Her scholarship and activism reflect her commitment to justice, equality, and social rights. Ma'am, the stage is yours.
Thank you, Aksharaditya. So, Honorable Justice Shah, respected panelists, including my friend Professor Rishikesh Dubey, I can see that he's there in this program, organizers and dear participants. Good morning to all. I would like to begin by congratulating Ayush Pandey, Sakshi, Aksharaditya, and the entire team of Jus Corpus for organizing this conference on the theme Towards Gender Justice, Reassessing Laws, Societal Barriers, and the Path Forward, in collaboration with the School of Social Sciences and Interdisciplinary Studies, RGNUL Patiala, Institute of Legal Studies, Shri Ramswarup Memorial University, Lucknow, and the School of Law, Sharda University, Greater Noida. Towards Gender Justice, an apt title for this conference, extremely pertinent in contemporary times, when the BNS has acknowledged gender to include men, women, and transgender. See, earlier it was restricted to only the male and female binary. Gender justice is important in order to protect the rights of all humans. In addition to legislative changes, this goal requires a change of perspective. The subject has to change from mankind to humankind. When we talk about gender equality, this refers to equal chance for women and men in allocation and access to resources and services. This is measured in terms of equality of opportunities and equality of results or reward for labor. And this is possible only in a world where sex-based discrimination is non-existent. We all know that the basic law of our country, which is the Constitution of India, it proclaims equality for all, which means that no one is to be discriminated on the grounds of caste, creed, or sex. And it also talks about providing equality of opportunity to achieve the goal of equality. Article 14, which is closely followed by Article 15.3, and 15.3 goes a step further and permits protective and a proactive approach for ensuring equality to women in all spheres, by rather allowing the state to make special provisions for them. So we have schemes to educate our girl children. They have equal rights in property now. The law safeguards them not only in the public sphere, but also in the private sphere. Now we have the domestic violence law also. More women are coming out to work. The laws have evolved to give them equal wages, safety from sexual harassment at work, maternity benefits, child care leave. Now all this has been done to enable them to discharge their roles of a worker as well as a homemaker successfully. So on the face of it, we cannot deny formal equality to women, can we? But in our hearts, we all know that the reality is far from what we would want it to be. So this was about men and women. But what about those who do not conform to the existing binary? We have conveniently compartmentalized all humans into men and women. And anyone who does not fall into any of these two categories or watertight compartments, now they make us uncomfortable. So whether it is queer, whether it is trans people, they are struggling to be acknowledged as human beings. The society treats them as some despicable specimen of humanity. And people have different theories. Some say that maybe they are suffering from some disease, hormonal imbalance, maybe it's a curse, maybe it's a twisted psyche, and whatnot. So, people need to understand the difference between sex and gender. These are two terms which are not the same. They cannot and they should not be used interchangeably. Sex is the biological differentiation between women and men, which is determined by genetics. It refers to the different biological and physiological characteristics of males and females, such as reproductive organs, chromosomes, hormones, etc. And the concept of gender, it's a social construct. So it's been constructed by society and it is unique to us humans. See, majority people conform to conventional two categories, male and female. But gender is a spectrum. And there are so many people who fall outside these two conventional categories. So, cisgender is the term which is given to those of us who identify mentally with the gender that we were assigned at the time of birth. And transgenders are those whose assigned birth sex does not match the gender of their mind. So, if we talk about the historical perspective relating to transgenders, the Britishers had enacted the Criminal Tribes Act 1871. This was a law which criminalized and which surveyed hijras. So this was a law which was repealed after independence in 1952. 2009, a monumental judgment, Nas Foundation versus NCT of Delhi. The Delhi High Court decriminalized consensual same-sex relations between adults and held that 377 of the IPC, it violated constitutional rights to privacy, dignity, equality, and non-discrimination. The court, in that case, it interpreted sex, which is given under Article 15, to include sexual orientation also. Thus, LGBTQIA plus people, these were protected from discrimination. So by reading down 377, the court decriminalized private consensual acts between adults while retaining the law for non-consensual acts and sex with minors and also for bestiality. This was a progressive decision which paved the way for greater recognition of LGBTQ rights in India. And finally, we got a decision in Navdeep Singh Chauhan versus Union of India. But in 2012, there was another big event that happened, that 2nd July, which was the date of decision of this Nas Foundation. That date was started to be celebrated as the Indian coming out. This was to mark the Supreme Court judgment. But then this was short-lived because in Suresh Kumar Kaushal and another versus Nas Foundation, this was a 2013 judgment, the Supreme Court set aside the Nas Foundation judgment and they recriminalized even consensual same-sex activity. Then in 2014, which was Nalsa versus Union of India, the Supreme Court recognized transgender persons as a third gender and affirmed their fundamental rights under Articles 14, 15, 21. And the court also directed the government to grant legal recognition and treat transgender people as socially and educationally backward and provide reservations to them in education and public employment. Coupled with the Puttaswamy judgment in 2017, wherein the Supreme Court recognized the constitutional right to privacy, which includes the right to sexual orientation and gender identity, all this strengthened the legal foundation for LGBTQ rights. Then in 2018, Navdeep Singh Chauhan versus Union of India, the Supreme Court unanimously struck down Section 377 as unconstitutional, which was and they decriminalized consensual same-sex relations. The petitioners argued that 377 violated their fundamental rights to equality, freedom of expression, and also personal liberty that are guaranteed under Articles 14, 19, and 21. A 5-judge bench unanimously held that Section 377, as it applied to consensual acts between adults, was unconstitutional. The court emphatically stated that the law was arbitrary. It encouraged discrimination and stigma, and it infringed upon the rights of privacy, dignity, and autonomy. The judgment emphasized that constitutional morality, not social morality. So it is constitutional morality that must guide the interpretation of rights, and all citizens are entitled to equal protection and dignity. Justice Indu Malhotra had stated, and I quote her, "History owes an apology to these people and their families. Homosexuality is a part of human sexuality. They have the right to dignity, free from discrimination." And what Justice Chandrachud stated, he said it's difficult to right a wrong by history, but we can set the course for the future. So this was a case which involved much more. This was not only about decriminalizing homosexuality. It was about people who wanted to live with dignity. So in 2019, our legislature took a monumental step towards gender equality by enacting the Transgender Persons Protection of Rights Act. This law was enacted by Parliament to provide a statutory framework for protection of transgender rights. It gives definition to transgender persons, prohibits discrimination, and provides for legal recognition of gender identity. However, it requires a certificate of identity from a district magistrate, which could be problematic at times. And this law has also been criticized for not fully addressing issues like marriage, adoption, self-identification, and others. So gender inequalities, whether we are talking about man, women, trans people, these gender inequalities, they remain deeply entrenched in the societal norms, despite the state's responsibility to uphold women's rights and protect them from any kind of discrimination. Most of the communities and almost all religions, they perpetrate patriarchy. And this patriarchy makes us gender insensitive. So patriarchy in its wider definition, it manifests itself in institutionalization of male dominance over women in society. And in our tradition-bound society, women have always been subjected to social, economic, physical, psychological, as well as sexual exploitation. In fact, the institutions of family and marriage, where she is considered to be safe, have become the major cause of her oppression. The forms of oppression may vary, but the content is the same. It is excruciating, it is overpowering, it is emaciating, and it is agonizing. So the dominant familial ideology in India, it has shaped and constructed the family as private, due to which it is beyond state intervention, and this immunizes the oppression of women within the domestic sphere. Whenever there is an effort to prohibit these violent and oppressive practices within the family, so we resist it. We believe that it's an undue intervention in the private sphere of family. Nowadays, we have also witnessed a reverse trend in which men are also becoming victims of domestic violence. Now, this is an area which needs to be addressed. It is not man versus woman. We need to understand that it never was between man and woman. It is all about humans, and it is all about right of every human being to live and express themselves freely without any fear of discrimination. We have so many laws, yet we do not see the change that we desire. Despite all our constitutional exhortations of gender parity, women and trans people are still treated as lesser humans, and they are discriminated on several accounts. This is because socialization and genderization, they shape our beliefs and attitudes. Gender stereotypes cloud our perceptions, and they limit our capacity to comprehend the problems that are faced by women and trans people in all walks of life. What is required is to shed our preconceived notions, demolish the stereotypes, and mainstream gender considerations in all spheres of our lives. So I would just like to conclude by saying the path forward can be paved by only demolishing societal barriers in addition to reassessing our laws, which is exactly the theme for this conference. Very wisely chosen, this theme. Again, congratulations to the organizers. So kudos Team Corpus for organizing this conference that compels people to agitate their minds and think about ways and means to bring about the change that we so much desire. Thank you, everyone. Good day.
Thank you so much, ma'am. Next, we have Ms. Taruna Prasad, an advocate on record practicing before the Supreme Court of India with over 21 years of distinguished legal experience. She has served as the standing counsel for the state of Jammu and Kashmir, representing the state in matters of constitutional and national significance. Her professional journey also includes a tenure as a partner at Fox Mulder, where she handled high value and complex disputes for tier 1 firms and multinational corporations. Her practice is marked by a very strong command of litigation strategy, precise legal drafting, and effective advocacy. In recent years, she has developed a focused expertise in family law, addressing sensitive issues relating to marriage and child support. Alongside litigation, she actively promotes counseling and mediation, helping families move toward peaceful and harmonious resolution. Ma'am, the stage is yours.
Many thanks, Akshay. Good morning, everyone, and heartiest congratulations to the team. Your presence here today is a reminder of the shared journey we are on towards change. India's population of 1.46 billion includes 68.59 crore women, almost half of our strength. Yet, this half still struggles for the basic assurances of equality, dignity, and freedom promised by the Constitution. Despite progressive laws and landmark judicial interventions, gender justice often remains an unfulfilled aspiration. Today, I will focus on three key aspects which has been designed by the organizers: the law in place, the barriers we encounter, and the path towards through gender sensitization guided by our courts. Now, I'll start with the law and judicial foundation. As we look at the law and judicial foundation, I will briefly share some landmark judgments that has continued to shape the understanding of gender justice. Though few has been covered by my laws and ma'am also, but there are a few more which I would like to share here. The first judgment which I want to share with you all is of Hisnera Khatun versus the state of Bihar, that is of 1979. That petition was filed on behalf of a woman under trial, prisoners in Bihar, many of whom were languishing in jail for years for petty offences simply because they were poor and had no access to lawyers. The Supreme Court declared that right to speedy trial and free legal aid are fundamental rights under Article 21 and Article 39A. Seen through the lens of gender equality, in this case of Snera Khatun, which is most popular one, and the case is a significant because it highlighted how women, especially because how women, especially from the marginalized communities, are doubly disadvantaged by poverty and the systematic neglect. It reinforced that true justice for women requires not justice in equality in law, but access to justice so that woman is denied her dignity or freedom because of her social and economic status. Relating to this case, with my experience, I would like to share that when the under trial, when a male member is there and his family, in fact, whole village approaches to the lawyer that he should be set free from the charge and his case should be contested. But I have seen in case of women, their family abandoned even if they are coming back. So that is the very sad part of it, ki how the women are treated if anything had happened. They are also human beings. But still the society till date, even the free legal aid, till date, this for the treatment towards female is not as fair as we have for the men. The second judgment, interestingly, is on service law. That is Air India versus Nagesh Mirza, 1981. Here, the Honorable Supreme Court struck down discriminatory service rules by air hostesses, which required them to retire at age of 35 on marriage within 4 years of service or on their first pregnancy. Male staff face no such restrictions. The court held these rules to be arbitrary, unconstitutional, and Article 14, calling forced retirement under on pregnancy, is a callous and cruel act, an insult to Indian womanhood. The judgment was a significant because it had upheld the principle of substantial equality, recognizing the true equality. T means removing unfair disadvantages rooted in gender stereotype. The third, which has already been referred by my laws and ma'am also, that is another landmark, Vishakha versus State of Rajasthan of 1997. This was on sexual harassment at workplace. The Honorable Supreme Court stepped in and framed the famous Vishakha guidelines, recognizing the sexual harassment as a violence of Article 14, 19, and 21. These guidelines lays down the foundation of the sexual harassment of women at workplace. The case is of significance because it acknowledged a woman's right to safe and dignified workplace at a part of her fundamental right. This is Vishakha judgment. I would like to share this fact also. This is not in India, but the guidelines set by the Honorable Supreme Court has been adopted by the neighboring countries like including Sri Lanka, Bangladesh, Nepal, and Pakistan. So, how the courts are stepping in to balance the balance the system. Now, the fourth is Shaira Banu versus State of 1940 Union of India. This is of 2017. As sir has already mentioned, this was of triple talaq, where Muslim men could instantly divorce their wives by uttering talaq 3 times. The Honorable Supreme Court declared this practice unconstitutional, holding it arbitrary, violative of women's fundamental right to equality and dignity. So, ma'am has already elaborated and covered this Nalsa versus Union of India that was on transgender and LGBTQ. The Honorable Supreme Court again held that sexual orientation is an essential part of privacy, dignity, identity. Together, these cases mark the historic shift by expanding constitutional morality to protect the rights of transgender and LGBTQ persons, breaking through long-standing heteronormative and gender barriers. Now, I would like to mention here the nuance, the balancing gender justice, because on pursuit of gender justice must be nuance. The courts have reminded us that women can not always be seen only as victim and all men always as an offender. Recent judgment where I was preparing for this, I just gone through the before that, this Arnesh Kumar, definitely another historic, where we had seen that women started victimizing themselves and misusing Section 498A. So this Arnesh Kumar versus State of Bihar, 2014, the Honorable Supreme Court misaddressed the misuse of Section 498. Dowry harassment. The court directed police not to automatically arrest husbands and in-laws, but to follow proper procedure. This step ensured that while genuine victims get justice, innocent families are not harassed by misuse of law. The two recent judgments which I was mentioning of the Honorable High Court of Madras recently reminded that law is not always black and white. It's an observation that Section 46(4) of the CRPC, which prevents arrest of women after sunset and before sunrise, is directory and not mandatory, may appear to weaken protection. Yet it highlights the need for a balanced approach where women's dignity is protected without creating loopholes that impede the justice. Another is of Archana Patil versus State of Karnataka. This is another interesting case. The court held that even women can be. Here, the Karnataka High Court declared that POSCO Act is a gender neutral. POSCO Act. The court held that even women can be prosecuted for sexual harassment under Section 4 and 6. This is a groundbreaking. It dismantles the stereotypes and ensures there's accountability regardless of gender. The focus rightly is on the child's vulnerability, not the identity of the perpetrator. These judgments remind us that gender justice cannot mean reverse discrimination. The goal is not to flip the scales but to balance them, ensuring fairness for all. The social barriers which we still face, the progressive judgment alone cannot break centuries of patriarchy. Stereotypes still holds us back. Women are told how far they can go in their careers, and men are told caregiving is not their role. Access to justice, as the Husnaira Khatun case showed, is still not equal. Women from rural area, Dalit, tribal communities often face many more hurdles before they are even heard. Our institution not always sensitive. Survivors survivors of sexual violence are sometimes made to feel traumatized all over again. At workplace, even after Vishaka and Posh Act, silence continues because fear and stigma stop women from speaking up. And most importantly, the most vulnerable Dalit women, tribal women, and trans persons are often invisible in the system. If we are serious about gender justice, we cannot leave them behind. Well, in the end, the path forward gender sensitization, we can see education, introduce gender sensitization in school curriculum to reshape attitudes early, institutional training, mandatory sensitization for judges, police, and workplace in the spirit of Vishakha, workplace culture, where we can build safe, transparent system, mentorship, zero tolerance for harassment, and equal opportunity practice, media responsibility as recognized in Awik Sarkar versus State of West Bengal. Media representation matters, stereotype must be challenged. Men's as partners. Equality is not a woman's issue. Men must be allies in dismantling the patriarchal norms. Transgender legal institutions. For law schools to the highest courts, we need merit-based transparent system, judicial appointment follows clear criteria, professional body must have accountable leadership and promotions must be communicated openly. Only then we can institution truly embody gender justice. Um, Gender justice is not a single reforms, a single law, or a single movement. It's a continuum. It stretches from a constitution to the courtroom, from the workplace to the village, from the digital sphere to the global stage. As lawyers, activists, policymakers, and citizens, we carry the responsibility to ensure that promise of equality is not a promise of deferred. To borrow from Dr. B.R. Ambedkar, constitutional morality is not a natural sentiment. It has to be cultivated. The cultivation of the morality, especially in the sphere of gender justice, is our collective task. Let us not see gender justice as a woman's issue. It is a human issue. It is a constitutional issue. And above all, it is a justice issue. Many thanks, team. Many thanks.
Thank you so much, ma'am. We are also pleased to welcome Ms. Mohini Priya, an advocate on record at the Supreme Court of India and a certified mediator with the Supreme Court Mediation Center. A graduate of Government Law College, Mumbai, she has built a versatile practice spanning constitutional law, medical legal issues, service law, media law, IPR, arbitration, and litigation. She has played a pivotal role in landmark public interest litigations, including challenges to the Surrogacy Regulation Act 2021, advocacy for reforms in organ transplant rules, and regulation of private coaching institutes as policy advisors at the India Child Protection Forum, led by Nobel laureate Kailash Satyarthi. She has contributed to the critical child rights legislation, a prolific writer on legal and social issues. She was honored with the Lex Falcon Global Award 2023 for a remarkable work. Ma'am, the stage is yours.
Thank you, Akshat, for that introduction. And thank you to the entire team of Jus Corpus for organizing this and for providing such a platform for meaningful discourse. As my fellow panelists have already addressed several issues relating to gender justice, I would confine my address to issues that I specifically deal with, which is reproductive rights. I would also like to deal with violence and social control, as well as representation in the bar and the bench. Now, gender justice, as already discussed, is not just a woman's issue. In fact, it is a societal imperative, a measure of whether our democracy is truly inclusive and our laws truly just. Various laws have been framed by the legislature to ensure gender equality. Yet in 2025, women across the globe continue to be told how to live, what to wear, how to reproduce, and even how loudly they can demand their rights. Starting with reproductive rights, reproductive choice remains one of the most contentious and urgent frontiers of gender justice. Our laws and policies claim to empower women, but if we look closely, they are riddled with contradictions and silences that betray an underlying mistrust of women's autonomy, which is guaranteed under Article 21 of the Constitution of India. Let me begin with the Medical Termination of Pregnancy Act 1971. On paper, the law appears progressive. It extends access to safe abortion up to 24 weeks for certain categories of women and recognizes the need for confidentiality. In fact, the Honorable Supreme Court in the case of X versus NCT of Delhi, which is a 2022 case, took a further step by affirming that even unmarried women are entitled to abortion up to 24 weeks, emphasizing that reproductive autonomy is intrinsic to Article 21 of the Constitution. Similarly, in the case of Shuchita Srivastava versus Chandigarh Administration, which is a 2009 case, the Honorable Supreme Court declared that a woman's right to make reproductive choices is a dimension of personal liberty. Yet, despite these pronouncements, the MTP Act continues to reflect deep gender inequalities. Women are not granted abortion as a matter of unconditional choice. They have to justify their decisions within narrow grounds, such as risk to health, failure of conception, fetal abnormality, etc. In practice, this means that doctors, medical boards, and courts can retain gatekeeping power over what should be a woman's private decision. The law assumes that women cannot be trusted to decide for themselves. Their autonomy is filtered through layers of paternalism. Add to this is the stigma and fear of judgment in hospitals, especially for unmarried women, and we see how access remains heavily compromised. So the very idea that termination of pregnancy is a concession rather than a guaranteed right exposes the patriarchal undercurrent of the law. Now contrast this with the domain of assisted reproductive technologies and surrogacy. So the Surrogacy Regulation Act 2021 and the Assisted Reproductive Technologies Act 2021 were touted as reforms to bring order into a field long criticized for exploitation. But these laws too carry the heavy hand of patriarchy. Surrogacy is permitted only for married heterosexual couples, thereby excluding single women, widows, and divorcees outside a certain strict age bracket, and LGBTQ plus persons and others who do not conform to the state's visions of a legitimate family. This exclusion is nothing short of structural discrimination in the society. Even within marriage, women's autonomy is diluted. These laws require the mandatory consent of the husband for IVF procedures, embryo transfer, and surrogacy. This means that a woman's reproductive future, whether she can use her own frozen embryos, whether she can become a mother through surrogacy, depends on her husband's will, even though she has been abandoned or deserted by the husband. I've handled cases like that. So I've also seen in my work how this plays out cruelly in real life. A woman facing divorce may find herself barred from accessing her embryos. Another, abandoned by her husband, may be left with no recourse because the law treats her husband's consent as superior to her own. In such cases, the law doesn't just protect women, it betrays them. The situation is even more precarious in cases of coercion. Many women are pressured by families to undergo surrogacy or egg donation, often under financial or emotional duress. The law pays lip service to informed consent, but fails to account for the power imbalances that make women vulnerable to exploitation. And while the ban on commercial surrogacy was intended to protect surrogates from exploitation, it has in fact erased their agency altogether. And by outlawing compensation, the law denies women the possibility of safe, dignified, and fairly remunerated work, pushing the practice underground, where protections vanish. So surrogates, who are often poor women, remain invisible, unprotected, and voiceless in the system. So we see how together the MTP Act and the Surrogacy and the Assisted Reproductive Technologies Act reveal a striking paradox. In matters of abortion, the law questions whether the women are making the right decision. In matters of surrogacy and IVF, the law forces them to obtain permission from others. In both cases, women's autonomy is curtailed, whether by the state, by doctors, or by the male counterparts. Now, what does true gender justice demand? Demands that we trust women and their choices, that abortion be recognized not as a conditional allowance, but as a right, free from unnecessary approvals and stigma, that surrogacy and IVF laws recognize women as independent decision makers, not as appendages to their husbands, that divorced, deserted, single, and LGBTQ plus persons be recognized as legitimate claimants to parenthood, and that surrogates be not seen as vessels, but as workers with rights entitled to dignity, health protection, and fair compensation. Now, our constitutional vision is one of liberty, equality, and dignity. These values cannot coexist with laws that infantilize women and force them to negotiate their reproductive choices through layers of control. As the rollback of abortion rights in the United States reminds us that the reproductive freedoms are never permanently secured. They must be vigilantly protected, constantly defended, and continuously expanded. So if we are serious about gender justice, then we must move beyond rhetoric and reform our laws to reflect the lived realities of women and believe that reproductive autonomy is not just a privilege, but it is a right. Now, next, I come to representation in the bar and bench. Now, representation is power. It is a principle that echoes through our classrooms, courtrooms, and corridors of power. Today, nearly half of law graduates in India are women, a vibrant, ambitious cohort shaping the future of justice. Yet, as we ascend the ladder from law school to senior advocacy, from the bar to the bench, their presence tapers off dramatically. The glass ceiling remains stubbornly intact. Consider this: the Supreme Court of India, with its sanctioned strength of 34 judges, has just one sitting woman judge today. Even when women edge closer to elevation, the path isn't always clear. As has recently been in news regarding Justice B.V. Nagratna's dissent, who is poised to become India's first woman Chief Justice of India, she registered a rare and powerful dissent in the collegium's recommendation to elevate one judge as against 3 senior women High Court judges. What is more telling is that her dissent has not even been made public. This has been supported by various women lawyers of the bar. And this moment is not just about one judge's dissent, but it is about a system that still resists inclusive leadership. Coming with dissent, our system has always also seen some reforms in the recent past. Earlier in 2024, the Supreme Court made history by designating 11 women as senior advocates in one round, the largest number ever conferred at once, bringing the total count to 18 since the year 1966. Now, this is still a very small number if we look into the larger scheme of things, but things are definitely changing, as we can see. Now, these 11 senior advocates included first-generation lawyers and 6 women under the age of 45, breaking the norms on age, lineage, and gender. The presence of the then CJI, Dr. D.Y. Chandrachud, and Ms. Kiran Suri, who was the first member of the selection committee, drove this shift. In May 2025, the Supreme Court mandated structural inclusion within the Supreme Court Bar Association. The role of secretary, 1/3 of executive committee, and 1/3 of senior executive posts were reserved for women, a gesture that went beyond tokenism. These are not just milestones, but these are templates for change. So turning back to Justice Nagaratna's lone dissent, this was more than just a disagreement. It was a call for honesty and equity. It unmasks how systems can sideline women even at the highest levels. When the voice of a sitting woman judge is sidelined and a dissent is hidden, what message does the system send to women lawyers, colleagues, and communities? Representation matters not because women are exceptional, but because institutions require their perspective, strength, and ethical leadership. We must ask ourselves, are we building a system where women are not once in a blue moon anomalies, but integral present voices at every decision-making level? So now at this stage, what should we demand? What should be the way forward? Maybe publish dissent notes when they arise in collegium decisions, and women's voices should not be muted. Institute structural representation in bar association, high court, senior roles, not as a charity, but as a correction. Regularly nominate women judges to the Supreme Court, not sporadically, but consistently, and empower women in committees and leadership bodies. Now, next, we come to violence and social control, which is the last topic that I'll be dealing with. And globally, the World Health Organization reports that 1 in 3 women will experience physical or sexual violence in their lifetime. In India, you remember the horror of the Nirbhaya gang rape in 2012, and most recently, the RG Kaur Medical College rape and murder case in the year 2024. These are not isolated incidents. They remind us that violence against women continues to be wielded as a brutal tool of patriarchal control. Our courts have tried to push the needle forward. In Vishaka versus State of Rajasthan, the Supreme Court laid down historic guidelines against workplace sexual harassment long before Parliament even acted. Yet, more than a decade after the POSH Act of 2013, we find that the implementation remains weak. And the gap is sharpest in the informal sector, where women work without the shield of formal protection and are most vulnerable. Equally urgent is the intersection of caste and gender. The persistence of caste-based sexual violence, as we saw in the Hathras case in 2020, is a painful reminder that gender justice cannot be divorced from caste and class. Dalits, Adivasis, and marginalized women face double discrimination, often silenced not just by perpetrators, but also by social and structural barriers. So where do we go from here? First, laws must not remain on paper. We need strong, accountable monitoring mechanism for POSH and other protective laws, extending their reach into informal sector and the gig economy. Second, justice must mean inclusion. Gender justice frameworks must be intersectional, addressing caste, class, religion, and disability, so that most silenced voices are heard and protected. Third, we must prioritize preventive systems like gender sensitization in schools, workplace training, safe reporting mechanisms, and survivor-centric support. And finally, change cannot be left to the courts or to the government alone. It requires a collective societal shift where institutions, corporations, communities, and individuals all commit to dismantling the structures that normalize violence. Now, I would just like to now collate everything that I spoke into what is the path forward. Talking about reproductive justice, there is a need for amendment of the MTP and the surrogacy laws to affirm women's autonomy beyond marital and heteronormative frameworks. When it comes to workplace safety, strengthen enforcement of the POSH Act, especially in the informal sector and the judiciary itself. Equal representation that we discussed in detail. Also, education equity. Prioritize girl education in SC, ST, and marginalized communities with financial, infrastructural, and social support, because the fight begins with education. Schemes like Beti Bachao, Beti Padhao sought to uplift girls, yet dropout rates remain highest amongst girls in SC, ST community due to poverty, child marriage, and cultural norms. We must push for scholarships, residential schools, digital access, and mentorship programs to ensure girls not only enroll, but also complete higher education. Education is the most powerful equalizer, and without it, gender justice remains hollow. And finally, we need an intersectional approach, which is to address gender alongside caste, disability, sexuality, and class to dismantle systemic oppression. Now, if we talk about the global feminist struggle, which is a shared cause, so we have to see that our struggle is not isolated. In Iran, women-led protests sparked by the death of Mahsa Amini in 2022, while in custody from improper hijab, became a global symbol of defiance against state control over women's bodies. In Afghanistan, the Taliban's ban on girls' education shows how fragile progress can be when gender justice is not institutionalized. In Latin America, movements like Ni Una Menos against femicide reminds us that violence is both personal and political. These movements inspire us to keep asking uncomfortable questions and demanding a radical change. So to conclude with, I would just like to say that the fight for gender justice is not charity, it is justice. And the path forward is not about giving women a seat at the table, but about reshaping the table itself. As the late Justice Ruth Bader Ginsburg once said, women belong in all places where decisions are made. So the question before us is, will we continue to wait for history to change, or will we be the one to change it? Thank you so much.
Thank you so much, ma'am. Our next speaker is Mr. Swarnendu Chatterjee, an advocate on record at the Supreme Court of India with over a decade of litigation and arbitration experience. He is currently one of the partners at Elective Law and has worked with leading law firms including Saraf and Partners, Ellen and Partners, and MAP Corporate League, and earlier assisted late Shri P.P. Rao and Honorable Justice P.S. Narasimhan. His expertise spans constitutional law, insolvency, banking and finance, commercial disputes, and white-collar crimes. He regularly appears before the Supreme Court, various high courts, NCLT, and other tribunals across India. Recognized internationally, he received the Lex Falcon Award 2021 and the Best Insolvency and Bankruptcy Lawyer of the Year India at Lex Talk World Conference, Singapore 20. Sir, stage is.
Yeah. Very good morning to one and all in this August meeting, and thankful to Jus Corpus for this conference and this topic, which is of magnanimity in today's context. So, beginning today, like towards gender justice, reassessing path, societal barriers, and the path forward. This topic reminds me of something my colleague, who is a lady, once shared with me. Like she had taken a break due to her owing to her pregnancy and childbirth, and she returned to the profession and began interviewing for jobs. In almost every interview, she was asked the same set of questions: what does your husband do? Who takes care of your child? If you are busy in the court, and clients who will look after the child. And while she wanted to negotiate the pay, she was told, motherhood is a handicap. No. So let us see. Now I want to pause and ask over here. How many men are ever asked this? How many men are asked when you are in office, who takes care of your child? This is the first bias, not in the law books, but in daily life. Like Wendell Holmes said, law is what we experience, not what is in the books. It is much different. The day we start asking men the same set of questions we ask women, we'll know gender justice has truly arrived. And if you think this bias exists in the offices and interview rooms, let me tell you how it plays in our courts as well. Now, just a couple of days back, there was a writ petition under Article 32 for seeking extension of POSH Act to the bar councils and the system of lawyers, which challenged which essentially challenged the judgment of the Honorable Bombay High Court, which denied such relief. Now, Justice Nagaratna, who is the first to be Lady Chief Justice of India, she was hearing the case, and the discourse as it would have. She said how first question was how it is maintainable. Now, keeping aside the technicalities and everything, she still issued notice and she asked for a reply of the Bar Council of India into it. This moment shows us exactly where India stands today on gender justice. Today, as I speak to you, I speak to you as a lawyer, as an advocate on record, and as a firm and as a partner of a law firm who has spent years watching the law promise equality but deliver it unevenly. Gender justice in India is not limited to one statute or one success or one event. It has been a long journey shaped by by our courts, our laws, our workplaces, our families, and our culture. Over the last few decades, our courts have given few powerful decisions like Vishakha versus State of Rajasthan, Madhu Kotwal Lele. We have also rewritten our criminal codes. The IPC has been replaced by the BNS, and the new laws on procedure on evidence have been in force since July 2024. India is certainly moving forward. I hate to admit that in real life that the gap between what the law says and what people experience is still wide. It is indeed wide. Let me give you 3 examples which starkly reveal the current state of gender justice in our country, or rather the glaring and painful absence of it. First one deals with the marital autonomy and the consent. The question of non-consensual sex within marriage counts as rape is still pending before the Honorable Supreme Court. Until that question is decided, a woman's consent inside marriage does not carry the same weight as it outside does. This, my friends, is not a gap, but a gap in dignity and in the most basic fundamental rights that belong to every woman, simply because she is a human being, equal to any man. Second illustration deals with the workplace safety. The POSH Act has been with us for more than a decade. Listed companies disclose data, but outside the formal workplace, protection is weak, rather non-existent. As I said earlier, the Bombay High Court has said that the advocates are not employees of the bar councils. The Supreme Court has now asked whether women lawyers should also be protected. Our profession is being tested on whether it follows what it preaches. Third illustration deals with bodily integrity and choice. The law now allows termination of pregnancy up to 24 weeks for all women, whether married or not. However, courts still face difficult cases beyond that limit. While one high court last month permitted a 17-and-a-half-year-old rape survivor to medically terminate her 31-week pregnancy, just yesterday, another high court refused termination of pregnancy to another minor rape survivor of pregnancy, but a 32-week pregnancy, holding that termination would be unsafe and life-threatening for both the minor and the fetus, especially given the women of the medical board. This in fact shows the cruel reality. 2 young rape survivors went to the court with the same plea. One was allowed to end her pregnancy at 31 weeks. Other was denied at 32 weeks. Their fate depended not on dignity or autonomy, but on medical opinions and judicial discretion. When a woman's right over her own body becomes uncertain, conditional, and uneven, that is nothing but gender injustice. When a woman's control over her own body depends on chance and discretion, justice already is absent. However, let us be honest, laws by themselves cannot do the heavy lifting. If the law opens a door, but society and the economy keep it locked, progress stalls. We all know that despite grand claims and efforts on paper, women's participation in the labor force remain painfully low. If statistics are to be believed even today, only about 1 in 3 women work, and far fewer hold stable salaried jobs. Without childcare, safe public transport, and workplaces that do not punish women for being women, equality on paper will never become equality in life. Perhaps this is why Justice Nagaratna had refused to let a technicality bury the real issue. She knows exactly what is at stake. And it is worth remembering that on 25th September 2027, she will perhaps become India's first women Chief Justice, but only for 36 days. Think about that. After more than 80 years of independence, our first woman Chief Justice will serve just over a month. If that does not tell us where gender justice stands in the country, whether in pay, parity, or positions of power, I don't know what it does. That is why we need more Justice Nagaratnas. And this is the heart of what I want to leave you with. Gender justice is not a women's issue. It is the foundation of a fair economy and the soul of the rule of law. We already have judgments and data. What we now need are deadlines, budgets, and consequences. My ask is simple. Decide the marital rape challenge. Strengthen posh compliance, especially within our own profession. Fund childcare and safe transport. And within the legal profession, lead by example. Publish pay equity. Prove that equality is not just arguable but inevitable. Equality does not execute itself. It needs enforcement. It needs planning, and it needs resources. But above all, it needs the first step to be taken in that direction. Let us commit starting today that gender justice will not only remain a promise, it will become a practice. Thank you.
Thank you so much, sir. We also have with us Mr. Abhinav Mishra, a first-generation lawyer and the founder of Chambers of Abhinav Mishra. He has been honored with the National Icon Award 2025 and the National Law Day Award 2020. Currently serving as Panel A Counsel to the Government of India before the Honorable Supreme Court, he has established himself as a distinguished litigant. His practice spans diverse fields, including white-collar crimes, arbitration, insolvency and bankruptcy, corporate and tax. Mr. Mishra has secured several reportable judgments before the Supreme Court, High Court, and tribunals. He is also empaneled with the prominent PSUs and Sir, the state.
Thank you, Akshay. First of all, a very good morning to all present. It's indeed an honor to be yet again invited by Ayush, and I am very grateful to the concept that has been taken forward this time that ensure that we have a stronger tomorrow, which is common for all the sex and the gender. So, as all the distinguished speakers today have already mentioned that what should be the way forward, I'll simply begin with giving an international law perspective of what gender justice equality actually means. If I have to begin with the definition of Article 1 in the UDHR, it simply reads that all human beings are born free and shall stand equal in dignity and rights. So even the first international document that transpired the involvement of fundamental rights in all the domestic laws also ensures that all the humans in the planet, irrespective of their gender, sex, etc., are to be treated equal with rights and dignity. So now when we take into the domestic law concept, these things become of utmost significance and hold a true value if followed and practiced in a particular direction to yield a result in the process. If I have to begin, I say that gender justice refers to the fair and equitable treatment of individuals, irrespective of their gender. It is rooted in the principle that men and women both and people of diverse gender identities must enjoy equal rights, opportunities, and dignity in both public and private lives. Over the period of time since independence, our laws have undergone a tremendous development in this regard. A number of amendments have taken place. Number of efforts have been even institutionalized to ensure that many a times the obligation of not being able to provide an equal opportunity to the female gender is taken forth and is settled at a pace at par with that of the males. If I have to begin, I say that the Delhi High Court executive committee also has a provision of having 4 women out of the 10 appointed members, which has been mandated from September 2023 onwards. Moreover, if we come to the educational aspect, the Kendriya Vidyalaya Sangathan, which is run by the central government, also enshrines a rule in it that if a girl child, a sole girl child, is to obtain education from the Kendriya Vidyalaya institutions, then her academic fee shall be exempted to the extent of paying the tuition, etc., the tuition fee, etc. So, what do we analyze from the examples that I have just cited? We analyze a number of things. The first one being that yes, in our country, gender justice is still a deep-rooted myth than being connected to a reality at a scenario when more than 75, 77 years of independence have passed. Second, the best of efforts of the day that we have and ensure that things work in the best manner for all the included individuals. The success in the direction is yet far to be achieved. The next one, I will not be focusing a lot on the judgments and all because my seniors who have already addressed, Justice Saab, Swarnendu sir, Mohini ma'am, they have all spoken a lot about the development in the legal aspects and or in the legal scenario that have transpired over the years. For me, the presentation would be more on a generic note because I will not be happy repeating the names of the case laws again. It gets boring for the audience as well. So even when we practice law, even when we sit in a city so developed, being Delhi, we see a number of occasions where despite the city being so advanced with all the technologies, with all the paraphernalia infrastructure, gender justice still happens to be kind of an ideology yet not understood by many. Law being a profession which otherwise entails a lot of struggles and hard work, a general perception exists, as Swarnendu sir was also mentioning it a while back, that one of his colleagues was being questioned that as to who would be managing the family, motherhood, things like those. So rather than changing the laws, rather than making amendments to them, rather than ensuring stringent provisions, efforts must be made to ensure that subsequent programs, lectures, seminars, webinars, they all are conducted at a national level, regional level, and more on the side of the rural level to ensure that the essence of the constitution is genuinely understood by the population at large, and the population at large understands this concept and works towards the collective good for all of us tomorrow. On this note, I believe that Ayush, sorry, I have a problem with remembering names, don't mind. Ayush has been doing a lot of good work in this regard. Every year we see him doing something or the other simply to ensure that the youth, the population, the mass at large is given or is made to imbibe the concept of what actually living a human life should be. Though it has a lot of aspects revolving around law, because Ayush himself is a practitioner of law. But then this initiative per se is something that if we take it into its true essence, probably we'll not have to go through a lot of case laws and judgments to understand what gender justice actually means. I'm once again grateful. I'm once again thankful to Ayush and the entire team of Jus Corpus. I wish this entire conference, the organizing team, all the very best. I pray and I'm hopeful that this will be yet another success of Jus Corpus. And if I may make a request to Ayush, that why don't you take down all the relevant discussions that we are having through this conference and submit it to the Ministry of Child and Women Development, and ensure that whatever are the takeaways from this conference are actually implemented in some or the other manner, so as to ensure that we just don't keep talking about such things and there is a day when such things actually ensure a better tomorrow for the entire population of the globe at large. So on this note, I am thankful again, and I wish all the colleagues sitting with me, I want to just thank all of you, sir and ma'am, for this simple reason that you could take your time out on this weekend and you could ensure that all of us sit together to understand where we are actually lagging and what needs to be done to ensure that we are at par with the developed countries and no more in the category of being a third world or a third country anymore. Thank you.
Thank you so much, sir, for the keynote, as well as acknowledging the significance of this platform. Next, we have Mrs. Munjal, an advocate enrolled with the Bar Council of India, practicing before the Supreme Court of India in various courts and tribunals. She has been counsel in several high-profile matters, including the Hon'ble case, concerning the Places of Worship Act and the Adina Masjid dispute. Mrs. Munjal has also been actively involved in the Kashi, Gyanvapi, and Mathura Janmabhoomi disputes, and she has challenged the constitutional validity of Section 494 IPC and the Places of Worship Act and the Waqf. In addition to her civil matters, she has considerable experience in handling criminal cases. Ma'am, the stage is.
Thank you so much, Akshar. I would like to extend a big thank you to the organizers who've provided us with such a good platform for us to share our perspectives on such an important subject. And I also express my gratitude to the esteemed dignitaries who just spoke before me about their thoughts on gender justice and have offered such valuable insights. They've set the tone for this discussion. So I'm very grateful for that. And to all the audience, Abhi ko namaskar. So I think we have all heard my esteemed colleagues before me. So I will try not to repeat as much as I can. So I will just focus on the gender justice that used to happen in ancient India from the wisdom of our ancient text. So before that, let me just begin with a quick question. Like, what comes in your mind if I talk about gender justice? If I say the word gender justice, what is that image that would come to your mind? It could be a courtroom, maybe lawyers in black robes. It could be a judge. It could be some modern debates on equality or feminism or something of that sort. But in our ancient India, justice, or as we used to call it, nyay, it was not about punishment. It was not about resolving disputes in the court. It was about restoration of balance. It was about aligning the society with the same harmony like the nature maintains between day and night, between the sun and moon, or between a man or a woman. So when we're talking about gender justice in Indian context, we are not talking about importing an idea from elsewhere or from the West, if I have to be specific. We are talking about returning to a balance that our ancestors, who not only understood it, but they also practiced it. So now that we're on it, let me take you back to 1,000 years ago to the Rig Veda. We have 4 Vedas, one of which is the Rig Veda. And it has a very remarkable verse. I will say it out. It says, Ajyeshthaso akanisthasa yete sam bhratro vavarudhu saubhagya. What this means is, no one is superior, no one is inferior. All are brothers. All should strive for the interest of all and progress collectively. So this is not a political slogan. It was a social truth that no one is greater, no one is above, or no one is lesser, no one is below us. So the women that were present, the women in the Vedic period that I'm talking about years ago, thousands of years ago, they were not only present in the society, they were visible. They were visible intellectually, they were visible spiritually, they were visible in public life. I will give you a few examples of those. There were women like Lopamudra, Gosha, Apala. They were the ones who composed hymns in the Rig Veda, which is being followed till date. And there were used to be rituals back in the day when both husband and wife were required to be present for that. There used to be massive yagyas that could not be completed without the participation of women by the side of the husband. There was a lady called Gargi Vachanakavi. She stood in the court and challenged the great sage of that time, Yagnavalkya ji, about the questions of what is humanity, who is a human, what do you call a human? There was another lady, Maitri. Her husband, when he decided to renounce worldly life, he wanted to distribute his property. She questioned that, can this wealth that you're giving to me bring any immortality? She was questioning, like, should I choose possession over knowledge? This is the kind of intellect that the women of that time had. That is the value of women that we had, that our culture possesses. So the underlying principle of this was, the core was that the Atma that is within us, the self that is within us, is genderless. The soul that is inside you or me, it is genderless. Even Swami Vivekananda ji has said that this soul has no sex, no caste, and no imperfections. So how can the concept of gender inequality or discrimination even exist? I mean, it is not just socially wrong in Indian context, it is metaphysically meaningless. I'll just briefly tell you a short story from our history. We all know about Chhatrapati Shivaji Maharaj. So I will not go into who he is because it is very well known, but I will tell you a short story about his mother. So when Chhatrapati Shahaji Raje, who was Shivaji Maharaj's father, when he was away, so Rajmata Jijabai, who was his mother, she managed not only the kingdom, but also the matters of governance. She played such a crucial role in shaping Shivaji Maharaj's values, his vision, and his leadership abilities. So there was this concept of Hindavi Swarajya, which refers to the concept of self-rule by the people of India, that is free from all the foreign denomination. So Jijabai Ma, she instilled in a young Shivaji a deep sense of duty, courage, self-resilience, justice to establish Swarajya, to be able to stand on our own, to be independent. That is the value of women in our India. So if Rajmata Jijau is born in every family today, a Chhatrapati Shivaji Maharaj can also be born in the family. So this tells us about what India stood when we talk about gender justice. But unfortunately, this equality, this respect that was given to women was not constant. It was because of some I would primarily state the reason to be the Mughal invasions, because of which customs like where the rulers would come and abduct women and harass them, torture them, rape them. And because of that, women had to perform customs like sati, child marriage. There was a parda system that became widespread, which was never our culture. So because of that, the values started deteriorating. And that was the historical point of view. And in today's time, I feel the biggest reason is the exposure to pornography at a very young age. Now, this exposure has been statistically linked to psychological distress, distorted attitude in relationships, And it has also increased the likelihood of engaging in sexually deviant behavior. So the normalization of obscenity in digital media, it contributes significantly to the objectification of women. And that has resultantly increased in sexual offenses and weakening of our societal values. And there have been estimates that suggest that nearly 30% of the internet is dedicated to this pornographic content, and a significant portion includes material that can be classified as pornography with minimal effort. But fortunately, with the help of my mentors, our whole team, Shri Hari Shankar Jain, Shri Vishnu Shankar Jain, Mr. Parth Yadav, we filed a petition before the Supreme Court of India, and the government of India has finally banned 25 OTT platforms that were publishing content like this, which has been a huge milestone for us. And now this is what brings the critical shift in our understanding of dharma. Originally, what dharma meant was upholding the cosmic order, but now it has just become a justification for social control, that is control over one gender. It has the freedom of the woman that our India produced gave way to the confinement of the medieval woman. That is very unfortunate in today's time, but there have been laws. The Constitution has brought forth Article 14, 15, 16, where there have been several judgments. There have been significant laws like the amendment to the Hindu Succession Act, where daughters were given co-pasni rights. But despite all of that, and even the judgments that my esteemed colleagues mentioned, like the Vishakha, Shaira Bayano, and the triple talaq judgment, with everything, the gap is still quite significant. Like the violence against women still remains significantly high, be it domestic, sexual assault. Every day we're listening to cases from east, west, north, south, something or the other is happening. The education gap is quite significant, but all of that is still there. But now there is a new dimension to it. There is a new dimension as to we have something that is called the need for, or the call for, gender neutral laws. Now, we do have Protection of Women from Domestic Violence Act. It protects women, but it is only designed for women. Now, there are studies conducted. There were men surveyed, which shows that half of them, 51% of them, reported intimate partner violence. Now, male victims of abuse have also no equivalent legal protection. So instead of trying to bring women on the same pedestal, now the men have also become the sufferers. Our rape law under the Bharatiya Nyaya Sanhita, which defines rape, is also in gender-specific terms, a male perpetrator and a female victim. It is always the male perpetrator and the victim is always the female. So this includes all the situations where a woman assaults a man. There are also well-documented cases of misuse, false allegations in dowry, domestic violence, and sexual assault cases, which can destroy reputations, careers, and families. So real gender justice, what would that mean? It would mean to protect every victim and punishing every perpetrator regardless of their gender. So what would be our way forward? I believe that it would rest on 3 pillars, and all of those are rooted in our own dharmic traditions. Number 1, reform laws in the spirit of ancient equality. We make succession, guardianship, and criminal laws, all of them gender neutral. We need to create a truly equitable framework, just as in the Vedic age, both men and women had equal agency. Number 2, use of dharmic language to change culture. Equality should not be seen as a Western concept. It was never that in our Indian context. It was always about nyaya, the balance. So we need to reinterpret the customs to reflect the principle that our soul is genderless. It has no gender. When we change our own mindset, that is where the change comes from. No matter what the government does, no matter what the parliament does, it begins from home. Everything begins from your own mindset. And number 3 would be empower through education and economics. We need to ensure that every girl every boy, they are provided vocational skill, entrepreneurial skills for upliftment. So in the end, I would just leave you with one food for thought that was said by Swami Vivekanand ji. He said that it is not possible for a bird to fly on one wing. Our society cannot progress if one half is held back. So that is something that we need to look into, that when we're talking about gender justice, it is not just man or not just women. It is our progress collectively. Gender justice is not a gift that is to be given. It is the restoration of our natural and moral order that our civilization, our ancient India once upheld. Thank you.
Thank you so much. Our next speaker is Professor Dr. Rohit Shabran, the Director of the Institute of Legal Studies at Sri Ram Farooq Memorial University, Lucknow. A gold medalist in LLB and LLM in criminal law, he earned his LLD from the University of Lucknow. He has presented over 75 papers at national and international conferences and authored more than 30 articles and 4 books on contemporary legal issues. Under his supervision, 6 PhD scholars have been awarded degrees, and he has also organized several conferences and delivered 16 lectures at reputed law. Sir, the stage is yours.
I am audible?
Yes, sir. Yes, clearly.
It's okay?
Yes.
Okay. Respected dignitaries, as esteemed scholars, faculty members, distinguished guests, and dear students, good morning to all of you. It is indeed an honor and a privilege to address this August gathering at the 4th virtual conference organized by Jus Corpus in collaboration with other institutions, RG, Annual, Patiala, Sri Ram Farooq Memorial University, Sharda University, and others. So the theme of this conference towards gender justice, reassessing laws, societal barriers, and the path forward is not just timely, it is critical. Because of that, if we see that yatra nare vastute pujyane devata, yatra vastu pujya te sarvastra phala kriya. This, if we have to translate that what I have translated, that where women are honored, there the goals delight, but where they are not honors, all actions and rituals yield to no fruits. So I think that with the thoughts of processing this connection with these main elements of this, that no nation can rise to the height of glory unless its women are side by side with them, with men. These words of Quaid Azam Muhammad Ali Jinnah holds a profound meaning even today. Gender justice is not a woman issue. It is a societal imperative and ethical obligations and fundamental human rights. If I will discuss that, take major 5 parts regarding this esteemed thoughts on the topic, that we have discussed that and divided into 5 parts. That is the meaning and urgency of gender justice, reasoning existing legal frameworks, societal and structural barriers, emerging challenges in the digital era, And the last is that if you discuss that the path forward, actionable strategies for transformation. So as we progress, I will share a real life example, if we can take landmark cases and global perspective to make our discussion concrete and meaningful. So in this regard, if the first point has been taken on the basis of the meaning and urgency of gender justice, what do we mean by gender justice? It is often confused with gender equality, but the two are not identical. Equality is about treating everyone the same. Justice is about recognizing differences and addressing historical disadvantages. So in this connection, consider this simple example. If two runners start from the same line, but one is carrying a heavy load while the other is the other is that is free. So giving them the same shoes does not ensure fairness. Justice means removing the load first. So gender justice involves substantive equality, not just formal equality on paper, empowerment, removing barriers to that women and gender minorities have equal access to opportunity, dignity and choice, the right to life, free from violence and discrimination. So why is this urgent? So according to the World Economic Forum's Global Gender Gap Report 2024, at the current pace, global gender parity will take 131 years. In this ranks, India has ranks 127th out of 146 countries. So women's labor force participation in India is around 25%. So among the lowest in the world. So every 15 minutes, a woman in India faces some form of violence. So the urgency is not just about morality. It is about national progress. And some reports estimated that closing gender gaps could add 770 billion to India's GDP by 2025. As Dr. B.R. Ambedkar Saab said that I measure the progress of a community by the degree of progress which women have achieved. So just in the connection, if we discuss that the second major points, reassessing existing legal frameworks. So in this regard, India has made significant legal strides toward gender justice. Our Indian Constitution itself is a beacon of equality. If we take Article 14 of Indian Constitution, that's give and says that guarantees equality before law. And Article 15 subclause 1 prohibits discrimination on grounds of sex. And Article 16 of Indian Constitution has to given the idea of ensures equal opportunity in employment. And in this regularly, we have to discuss that Article 21 provides the right of life with dignity. So director principles of policy, if we discuss regarding this, directive principles further strengthen this framework. If we take Article 39, subclause D, mandates equal pay for equal work. And Article 42 calls for maternity relief. Means that's take the Article 21 in labor laws that Maternity Benefit Act 1961. So important statutes that in this regard, in this connection, the Protection of Women from Domestic Violence Act, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, the Dowry Prohibition Act 1961, the Maternity Benefit Act 1961, and it is also amended in 2017. The Equal Remuneration Act 1976. Now under Code of Wages. So the Transgender Person Protection of Rights Act 2019 is also included in this connection. And if we have discussed the judicial landmark judgment in the landmark cases, if we discuss with the Vishaka versus State of Rajasthan 1997, laid the foundation for workplace safely and inspired the Sexual Harassment Act. And in this connection, we have discussed the different cases. That's the Lakshmi versus Union of India 2014, regulation of acid sales after a young woman brave fight against acid attacks. So Joseph Shine versus Union of India in 2018 discriminalized adultery, affirming women's autonomy. And next case in this connection, that Notej Singh Johar versus Union of India in 2018, discrimination homosexuality under section 377 of Indian Penal Code, but at that time now it is seen in as per the BNS perspective. So Independent Thoughts versus Union of India in 2017, Nirbhaya case. Nirbhaya case is a very landmark case and led to the Criminal Law Amendment Act 2013. So despite the robust framework, implementation remain a challenge. So conviction rates for the gender-based crimes remain low due to systematic delays and social stigma. And if we have discussed the main third point, which is divided by on my presentation, that societal and structural barriers, laws alone cannot dismantle patriarchy. Real change requires challenging deep-rooted stereotypes. Women are still expected to prioritize family over careers. Unpaid care work, Indian, I think that the whole Indian aspect, just like as in the case of Banwari Devi in 1992, a social worker gang rape for stopping child marriage, and highlights caste and gender-based violence. Her struggle led to the Vishaka guidelines, which became the foundation of workplace harassment laws. As we discuss, as someone behaviors wrote that is an important quotation. One is not born, but rather becomes a woman. So in this underlines that gender roles are socially constructed and can be dismantled. So if we discuss with the fourth important content of this presentation. Emerging challenges in the digital era. Technology is a double-edged sword. While it empowers, it also implies risk, cyber harassment, and trolling women journalists. The Rana Ayub face coordination online abuse. So, online crimes, the voice locker room scandal 2020 revealed toxic having the spaces in the digital space. Current laws, just like the IT Act 2000, need urgent updates to tackle cyber bullying and deep fakes and others. So, in this connection, we take the fifth, my main strength point, the path forward actionable strategies, legal reforms, economic policy measures, and education and awareness, and digital safety. Means amend the IT Act for deep fake regulation, promote cyber safety, education for women, develop AI ethics frameworks to prevent algorithm bias, and collaborative approach. So, if engage men as allies through campaign like HE for and she encourage corporate gender audit and diversity policies. So, in this regard, my concluding remark are closing thoughts of my side, that gender justice is not charity. It is justice. It is not about favoring women. It is about creating a society where everyone has an equal chance to thrive. As former UN Secretary, that Kofi Annan, General Kofi Annan has said that gender equality is more than a goal in itself. It is a precondition for meeting that the challenges of reducing poverty, promoting sustainable development, and building good governance. So, that from my side, that create that create the main theme and five main challenges from this particular topic. So, thank you for your time and attention, and I think that I have congrats to all the team members for that wonderful organizing this international conference, and thank you.
Thank you so much, sir. We also have Professor Dr. Rishikesh Dubey, the Dean of Sharda School of Law, with over 20 years of experience. An expert in human rights, international humanitarian law, and criminal law, he holds an LLM and PhD and was awarded a doctoral scholarship at the Hague Academy of International Law. He has held academic leadership roles at several universities and successfully secured prestigious grants, including 2 Erasmus Plus projects worth rupees 1.5 crore. Sir, the stage.
Thank you, Akshay. It's a pleasure to be present in this particular conference. So I thank Ayush for inviting me. This particular issue of women or gender is very important, and my previous speakers have very aptly and in depth analyzed the challenges faced by women in India, the laws, the cases, and all the analysis of those cases. So what I would like to do is to throw light, a bit of light, or speak a bit on the international scenario, because this being an international conference, I think we should be looking at certain aspects at international level which are very pertinent to women. Start with basic things, that in international law has several conventions, several provisions to protect women, and to provide equality to women at different places. Many are recognized very well by almost all the nations, but at the same time, the problems faced by women worldwide are quite alarming, and then also uh, it is same when it comes to developing nations, developed nations, and things like that. Few issues that are very core at international level are gender-based violence, which is especially seen in the conflict regions. Rape or sexual slavery or forced prostitutions uh, are considered as weapon during the armed conflict, because and this is not new. From time immemorial, this has been the practice which is done very rampantly in the war, in the conflict. So the Rome Statute, Article 71G, says that it is rape, sexual slavery, forced prostitution are crimes against humanity. Even Geneva Conventions, Article 27, also talks about protection of women against rape and forced prostitution. But at the same time, when you look at the international scenario, just look at the Ukraine war from 2022 till present. ICC is investigating almost 200 documented cases of sexual violence by Russian forces. In Myanmar, also, there are documented cases of rape by military against Rohingya women. Ethiopia, again, there is a widespread sexual violence going in the conflict over there. Even Congo, which is considered to be the rape capital of the world, the sexual violence has been on a large scale. Then there is also legal discrimination against women when it comes to equal work opportunities, equal educational opportunities, equal reproductive rights. And I will not just talk about Afghanistan and Iraq, where they are banning women from education, work, and public spaces, and also mandatory hijab laws. But I'm also talking about developed nations like Poland, like Hungary, where there is a ban. I mean, even USA, I think almost 14 states of USA, where there is a ban on abortion. Okay. So despite the European Court of Human Rights ruling against this particular rule, Poland, Hungary keep on enforcing ban on abortion. So this is another aspect. The next aspect is, the global wage gap. There has been a huge wage gap between what men earn and what women earn in the same job, same kind of conditions, right? Worldwide, the statistic says that women earn 20% less globally. And in countries like South Korea, that gap reaches to around 31%. So this is again a huge issue when we are talking about equality, when we are talking about equal pay for equal work, and at the same time we see this issue. Also in property rights, I was doing this research for this particular conference, and then I came to some statistics saying that there are around 104 countries in the world where women cannot own a land equally. This is a World Bank statistics, right? 1.7 billion women worldwide does not have access to banking system. Okay. So all these things, even if you talk about international community, like in International Court of Justice, only 5 out of 15 judges are women. When it comes to negotiations between the countries and between the peace negotiation, there are only 23% of negotiators who are women. Even in UN Security Council, there is no female permanent representative among the P5 members currently. So, looking at all these things, there is a huge path, which we have to cross in order to ensure equality, and that is where it is not just India, but almost all the countries of the world have to work a lot, to ensure that we are giving equal status to the women. This has been a traditional view. If you can see from the history, there has always been an effort, a right to give rights to the woman. But the problem is that whenever we are giving the rights to the woman, we are giving it as if we are favoring them, if we are doing some favor to them. And that is where the problem comes in. Okay. If we start accepting the fact that women are in most of the situations equal to men, they are more vulnerable in certain issues or certain problems, like, for example, rape during the wartime, and all those things, then only we can achieve equality, right? The second issue which I wanted to discuss, which will affect a lot, especially females, especially women, is the climate change. Because the problem which women face to handle a household, to ensure drinking water, to ensure food supply, to the family, all these things, the highest, what do you say, the biggest hit has been to women, especially because of climate change. There is a reduction, there is famine in certain areas. There are issues of clean drinking water, which is there. And all these things are first faced by women, then by men. All these aspects we talk about, are of international importance, even when we have a very strong, robust framework of the Convention Against All Form of Discrimination Against Women. We are still lacking in implementation of the same. Okay. The European Court of Human Rights also has a very strong jurisprudence when it comes to women's rights. But at the same time, countries like, example, if I say Poland or Hungary, they are not following the directives of even European Court of Human Rights. So, in short, the most affected groups among women are low-income women, rural women who have limited access to services and information, young women who face parental consent laws, in many countries, women with disabilities, where forced sterilization and denied reproductive choice are there, and refugee women because they do not have the proper rights when it comes to displacement. So all these things at international level, brings a lot of attention. And when we're talking about the scenario, let us remember one thing, that we are not, giving any favors to the woman. And that is where one very important aspect comes when it comes to the human rights. We all have seen in many instances that the writers, the scholars, the jurists, they use the term human rights of women. Okay. Now, that terminology itself is biased. Okay. There cannot be human rights of women. Human rights, the name itself suggests, are for humans. So any person who is a human has human right. There is a separate set of rights which are called women rights. And that is where we have to focus on. So woman gets all the human rights. In addition to that, they get something which we know as human rights. Okay. Now this difference is very important to conceptualize. Okay. Human rights are there. Now, when woman needs extra protection, okay, extra entitlement, extra empowerment in order to achieve, as my previous speaker was talking about, that one runner is having a lot of weight and another is wearing, sports kit and, good shoes and everything. Now, in order to ensure both are in the equal scenario, in equal setting, the woman rights becomes very important. And that is where we need to ensure that we all work towards the rights of the woman. And at the same time, we will not just, keep these rights in books. It has to be actualized, it has to be implemented, it has to be enforced with correct spirit. And that is when we will be able to see a day where we, the women and men, walk hand in hand. As my previous speaker said, that we all are one. There cannot be any difference between the two genders. And that is where we will see the equality and the dignity of women is protected at its best. Thank you so much for the time, and I hope I make sense. Thank you.
Thank you so much, sir. Finally, we have Mr. Ayush Pandey, an advocate practicing at the High Court of Judicature at Allahabad, Lucknow bench. He is a well-published and quoted author, as well as the publisher of the Jus Corpus Law Journal, India's highest indexed quarterly law journal. He has edited and co-authored 3 books and has extensive knowledge of alternative dispute resolution and criminal law. His contributions have earned him recognition from platforms such as Octopus and Cherry.in. For his remarkable achievements, he was also nominated for the Indian Young Achievers Award. Sir, I would like to conclude this inaugural ceremony with your able address.
Thank you so much, Akshar. A very good afternoon to everyone who have been present there, who is present here, as we come close to the inaugural session of the 4th virtual conference organized by Jus Corpus in association with the different esteemed institutions. It is my privilege to extend a heartfelt vote of thanks to all those who have contributed to making this event and the inaugural event a grand success. First and foremost, I express my sincere gratitude to our guest of honor, Honorable Mr. Justice Subodh Shah, former Judge Gujarat High Court, for being the guest of honor and his kind words, and to all the esteemed keynote speaker, including Professor Dr. Vageshwari Deswal ma'am, Ms. Taruna Prasad ma'am, Ms. Mohini Priya ma'am, Mr. Swarnendu Chatterjee sir, Mr. Abhinav Mishra sir, Mrs. Munjal ma'am, Professor Dr. Rohit P. Shabran sir, Professor Dr. Rishikesh Dubey sir, and to all the chairs and the co-chairs, the advance thanks to them who will be chairing the technical session that will take place post this inaugural session, and to all the participants who is going to participate in the conference by presenting their papers on the different subject matters that align with the themes. Your contribution truly reflects the spirit of legal scholarship and innovation that this platform seeks to encourage. We are also grateful to all the partner institutions, Rajiv Gandhi National University of Law, Punjab, Shri Ram Swaroop Memorial University, Lucknow, Sharda University, Greater Noida, for their constant support and trust, without which this event won't have been possible. My heartful appreciation goes to the whole dedicated Jus Corpus team, Mr. Akshar Adit, Ms. Sakshi Batham, Mr. Abhinav Shukla, Mr. R.N. Gupta, Mr. Darshan Rao, Ms. Navjot Kaur, Mr. Shashwat Tiwari, etc., for working tirelessly behind the scenes to ensure that every detail was taken care of from coordination to execution. This conference is a testament to your commitment and the hard work. A special mention to our sponsors from which we have been and the event have been powered by the Lectio Law Offices and the Chambers of Abhinav Mishra Advocates and Solicitors. We are thankful to them. Without them, this event won't be possible. Finally, a special thanks to our audience and attendees for joining us today and for your active engagement throughout the session. On behalf of Jus Corpus, I thank you all once again and looking forward to the continuing this journey of knowledge, dialogue, and growth together. With this, we formally conclude the inaugural session of the fourth virtual conference, wishing you all the very best in your endeavors ahead. Thank you. And just a small clarification. One of the previous speaker have mentioned about Mr. Jinnah, some quote. So we do not endorse that particular quote, and we apologize as on the behalf of the organizer and the speaker's behalf, and we take the words back from our side. Thank you so much, and all the very best to all the presenters, those who will be presenting their paper. Hope to host you soon in the near future. Thanks to all the guests, esteemed keynote speaker Akshar for hosting this session, and my colleague Ms. Sakshi Bhatam for being there on this side, and to all the internal members of the Jus Corpus team who have been there and who are waiting to start the technical session scheduled at 1 p.m. All the participants are requested to join the technical session at 1 sharp. Thank you so much.
Thank you, sir. As we conclude this inaugural session, as the master of ceremony, I'd like to extend my heartfelt thanks to all who have contributed to the event. First, I would like to express my deepest gratitude to all esteemed speakers who shared their invaluable knowledge and insight with us today. I'd like to thank our guest of honor, Honorable Mr. Justice Subodh Shah, for his strong and inspiring words aiding us in moving towards equality. Our keynote speakers, Professor Dr. Vageshwari Deswal, for her insights about the gender spectrum and inclusivity. Ms. Taruna Prasad for making us aware about the ongoing legal discourse about the theme with the help of landmark case laws. Ms. Mohini Priya for bringing into light the discussion on reproductive rights, the representation of women at the legal battlefield, as well as violence against them. Mr. Swarnendu Chatterjee for advocating the reality of the legal position of gender justice and gap inequality in national arena. Mr. Abhinav Mishra for bringing forth the practical aspects of gender justice and a reasonable path forward. Mrs. Munjal for bringing into discussion the evolutionary aspect of gender justice and the lessons it accompanies. Professor Dr. Rohit Shabran for explaining the concept of gender justice in a holistic manner using real life examples, statutes, and case laws. Professor Dr. Rishikesh Dubey for discussing the perspective of international law on the theme, as well as international scenario upon gender justice. And finally, Mrs. Sakshi Bhatam and Mr. Ayush Pandey for providing the platform for this discussion. Your expertise and dedication to the field of gender justice have made this a truly enriching and impactful event. A special thanks to our presenting partners as well as our sponsors. Finally, thank you to every participant who has joined us today. Your engagement and presence are a testament to the importance of the discussions we will have today. We hope this conference will provide you with actionable insights and a renewed commitment to promoting gender justice in your own work and communities. And now, with the insightful inaugural session concluded, we move to the core of our academic discussion. The paper presentations will begin shortly. These papers represent the culmination of dedicated research and will offer a diverse range of perspectives on our conference theme. I encourage all of you to listen closely and engage with the presenters during the Q&A sessions that follow. I request all the participants to join their respective technical session rooms and breakout rooms through the given link that was shared on your respective emails.